Well, the case is supposed to be very, very simple. With the aim of discussing it and commenting upon it in terms of the implementation of some of the principles included in the regulation. So there's an Italian citizen who is the heir from his mother who died in 2017, a flat in Lyon and some land near Palermo. Before getting married, he purchases a house in Paris. Then he gets married in 2019 with a Maltese citizen, and their residence is in Paris. Then they choose as an applicable law, the Italian law. At the end of the year, he purchases a shop in the small town near Palermo. In 2020, he purchases another house near Palermo, near the seaside in Cefalù, and in March 2022, he dies, and therefore she asks for the European succession certificate, which is supposed to entitle her to become the heiress of all her husband's property. Now, some of the elements apparently were not clear enough in the application. Anyway, when for example, at the beginning of the application, she asks for succession being covered by a given applicable law. Well, actually, the husband, independently of his citizenship, is supposed to have his habitual residence in Italy, since he may he may actually reside in Paris, but for a considerable amount of time, further to his moving to Italy until the time of his death, his residence may be considered as being the Italian one, as being in Italy. Since he did not choose otherwise, as under the regulation, the succession law will be the Italian law, since it is the law of the state of the man's habitual residence. Well, of course, the spouses may have agreed upon a different applicable law. That may well have been the case, actually, since the regulation on matrimonial property regimes, considering that they got married in March 2019, and therefore this is a marriage that temporarily falls within the boundaries of what envisaged by the regulation. Well, the spouses are entitled to choose as an applicable law the one of the state where one of them had the citizenship once the agreement was actually carried out, so pursuant to Article 22 of the regulation. So if this is the answer, then based on which criteria? And here the answer is widened, to include all the different elements. So the Italian law covers this even before the choice of the law. Well, here, this is another question, but here the answer is no, because when there's no choice of applicable law, then the applicable law falls within the scope of Article 26. So the first common residence prior to the wedding. So up until 2019, their residence is in France, but soon after that, there's a short time during which the French law applies, but after that, the Italian law applies. So they did choose the Italian law as the applicable law, which entails the communion of property between the two. So once again, the applicable law is the Italian one, as we have said. Now, what about the competent authority for issuing the European succession certificate? Well, this is a question that I have already answered, as a matter of fact. So the competence will be on, first of all, the notary, the relevant notary, since the Italian law shall apply, and therefore the competence in Italy precisely lies on the notary. What about the documents to be taken into consideration by the notary to certify the rights that the wife is entitled to as an heiress? Well, of course, the answer may have been taken for granted since she is the wife, although this is not part of what envisaged by the regulation. But anyway, this is already a prerequisite for the recognition of her rights as an heiress, as a legatee. And so then the competent authority shall also consider, as I said during my presentation, the matrimonial property regime. And we have already said that the spouses did make their choice of law, but they did not choose a conventional regime. Here, therefore, it is the legal one that applies. So, as a consequence, and I'm saying this mainly to the benefit of our colleagues online, so in Italy, there's a distinction between personal property and property being part of the communion regime. So the former ones include the property inherited by the dead person's mother. So they fall within a succession regime. As for the home, well, it is part of the property communion. Therefore, it will only be part of the legal inheritance by half. And the same goes for the business that he carried out further to purchasing space to be used as a shop. So the legal communion arises if there was a competence further to the dissolution of such a communion, which may indeed be considered. And within this framework, I am reminded of the judgment we mentioned before. Well, then the property shall be considered in half. And the same goes for the seaside property. I think I can be done here. Maybe other remarks will follow.